Let's turn now to William from Fairfield. William, we're glad you're calling in tonight. If you will, go right ahead with your question. William?
Hello?
Hi, William.
Yes.
Good evening to you.
Yes. Yes, good evening. My question is, I filed for bankruptcy back in 2020, and it was dismissed in the case in court. But my question is, I had already filed on. I was a member of a class action lawsuit on the earplugs, and I want to know, can I be dismissed from that, because they're saying that I'm gonna have to reopen that case and let them know that I was on a class action lawsuit already, which I didn't know that.
Boy, I'm getting some tough ethical questions tonight. As a bankruptcy attorney, we have to disclose any potential lawsuit you may have. Even if I slipped somewhere and I haven't even filed a lawsuit yet, I haven't even reached out to Kirby and his firm to file, if it's a possibility that I can collect money from someone by filing suit, it has to be disclosed in your bankruptcy petition, either 7 or 13. So yes, more than likely the trustee or the judge is going to ask you to reopen your bankruptcy case. The schedules will be amended to add that lawsuit, and any proceeds that you receive could potentially go through that Chapter 7. Chapter 7 is liquidation bankruptcy, and so a lawsuit with proceeds could possibly go through and pay some of your debts off that have before now been discharged. That's really something you need to talk to your attorney about, and they'll lead you down the right path. We've got some great attorneys in town.
And Gina, they can, like William's case had been dismissed, so they can literally make you reopen to put that lawsuit back in. So you need to disclose those to your attorney, right?
I'm assuming you meant discharge, is that right, in a Chapter 7?
Yes, ma'am.
Yes, dismiss is something that's not a word that we use in Chapter 7. Dismiss is in a 13, and you would not have to reopen a 13 if it was dismissed, but you would have to reopen a Chapter 7 after being discharged if there was a debt, an asset that wasn't listed.
And one question that William asked also, should he consider just dropping out of that class action lawsuit? Is that possible at this point?
That may not be possible. That once again, that's the trustee job. The trustee who steps into the shoes of the debtor and says, is this really an asset that the trustee can collect money for and pass it out to creditors? And let's say it's worth $300. More than likely the trustee is not going to be interested in it. But if it's worth $30,000, the trustee may say, well, you're staying in the lawsuit, you're not going to be dismissed. He will actively participate in that lawsuit on behalf of the debtor.
Okay.